Okay, so they saved the lawyers for the end. Poor you. I'm the last, so I'll be short. You had a rough day, a very interesting day.
No rush.
No. Okay, so I have a 2 hours. No, I'm just kidding. Thank you for inviting me first. And as mentioned, I finished my PhD thesis last year here in Tel Aviv University Law School, and I also research as Dr. Luria in the fields of labor and welfare law, and I teach here labor law. But I'm also an active attorney in the Justice Department, Haifa District Civil Attorney Office. But I'm here not on this capacity. I'm here as a researcher capacity. And of course, I want to talk about Dr. Luria's article. And first, I want to stress out, when you read it, this excellent article, the view it shows us is very grim, because it shows us regarding flexicurity that we have a flexible market but without no security. And of course, when I mean flexible to the employers, but with no security and no flexibility regarding the employees. And a few words to explain. The government, of course, does not offer a very good job training to the unemployed. And in this view, I must explain that the Israeli government actually quite diminished job training in the last 15 years. So when you're unemployed, we had a big discussion regarding what is called the Wisconsin program, which was privatized, which was operated by private entrepreneurs. And
just in a sense, what the Wisconsin program is for the benefit of
it actually said that if you wanted social benefits from the country, i.e., I mean, of course, benefits that for the unemployment, you have to do some kind of a job training, but this job training was operated by a private company.
Wait, hold on. Just for a second.
Jumping because this is sensitive spot with me. We did the evaluation together with the research department of the National Insurance Institute, and that's just not accurate, very inaccurate. Just in one word, Wisconsin project, funny that they call it Wisconsin, that's a welfare to work. That's the Israeli welfare to work project. For some reason they called it Wisconsin because they said it was modeled after Wisconsin State, after the program in Wisconsin State.
Yeah.
This was for income support recipients only, not unemployment insurance, which is not an income support. Danny didn't put it on this not insured. This is money that's given by the Ministry of Finance of the National Insurance Institute. It just pays, the institute only pays it. And according to that, according to the law of income support, the recipient has to take any job. It doesn't matter if he's a university professor. If he receives this benefit, any job, provided it suits his health condition, and they can send him to pick apples. And that's okay. It's not a training project. It is not a training. The whole orientation was work first. This belongs to the promise of work first. If there's a job for him, let him go to work. After a year that he was in a job, they offered him training and so on.
Okay,
So just for accuracy.
but there is no job training. I would say an official, very well for people who are unemployed. There is no wide range program in Israel coming from the government that is funded by the government for people who are unemployed.
Can I correct again? I'm sorry. We just finished a report for OECD on VET, on vocational education and training in Israel, which is going to be on their website in another month or so. There's a lot of courses. Maybe there can be a lot of criticism on the training department in the Ministry of Labor, but there are a lot of courses, and now, which is very popular, it's going to be more. These are the voucher project. People can, on their own, if they qualify by the employment service, they go and they get their own course, and the government reimburses them. They have to pay some of the money, but the government reimburses them. So this is a bit harsh, I would say.
Some of the courses have a big criticism on them that they're not efficient. That's the criticism I know, but
that's the criticism of universities too.
Okay. regarding other factors, there is a wide phenomenon which is of job discrimination, including age discrimination, and by this, Dr. Luria explains us the Shraga Cohen's case, which is very interesting, and I will talk about it more later. There are ungenerous unemployment benefits, and I just came back today I heard the Professor Dahan from the economic researcher from the Hebrew University, and he pointed out, he showed us all the OECD countries, and we've seen that Israel has the worst unemployment benefits all over the OECD. I think usually we mean by days paid to the unemployment, to the unemployed, and in this view, Israel pays sometimes maybe 25% or maybe 33% from the countries that are on the higher level, and this is a big problem. And the National Insurance Institute pension, i.e. the first year of the mandatory pension, is very low, as Dr. Luria shows us. But the interesting and most important insight in Dr. Luria's article, which she provides us, is that even in a labor regime where collective agreements rule, and we tend to think of collective agreements a regime that it supports the employee much better, she shows us even there, over there, an employee, he or she can be fired when the employer decides there is a just cause to fire him, and without the consent of the union. So the employee actually has no job security. And she also concludes, Dr. Luria, that job security, even in collective agreements regimes, is weak in Israel. So senior employees have actually no rights when it comes to job security and job training and so on in collective agreements. We must also remember, as the article emphasizes, that many workers in the Israeli labor market are not even covered by collective agreements. And we all remember Pure finding the primary labor market and the secondary labor market, and Israel is defined by a very big secondary labor market where there are no coverage or a low coverage of collective agreements, low wages, and so on. And we must remember that this sector is quite big in the Israeli labor market. So, a look to the future. What can and from where can a change occur? How can we protect seniors' employees' rights in a better way, especially regarding flexicurity? And the answer relies maybe in a combined action. First, the government has to offer solutions from her side. As discussed here, job training, maybe it's good, maybe it's not good, but this is an issue to talk about. The Knesset, the Israeli parliament, has to legislate laws regarding mandatory pensions, the right to flexible work hours. And by mandatory pensions, I must explain that the mandatory pension from 2008 and so on is from a collective agreement widened by the Ministry of Commerce. It is not by law, and when we talk about something that is not by law, it can be harmed more easily. So it's not so well defined as we want it. And another idea a colleague of mine, Dr. Isi Doron, talks about is flexible retirement age. The retirement age in Israel is rigid, as we know, 67. And, of course, maybe, and we talked about it outside, maybe we can think about flexible retirement age. Do you want to guess, people who are not from Israel, what is the one population that can retire over 67? They can retire at 70? Judges. Judges, okay, they can retire at 70, so this may be Israeli judges, and of course they do an excellent job until 70 and maybe even afterwards. And maybe we're not talking about flexible retirement age for everyone, but maybe certain groups. And third, the employees' organization must do a better job in protecting the rights of senior employees.
Why not for everyone?
This is a good question. A flexible retirement age is something maybe the employer will have a problem to deal with. Dr. Doron and I discussed, and there are articles in abroad talking about it, about checking the capacity of each employee. Maybe the employer has a problem with it, coming to every individual employee and checking him personally. This is something to be talked about. It's an interesting idea, but I think we should first approach it by looking at certain groups. And of course, I think about weak groups and certain maybe women groups. As we may know, we well know, they sometimes take care of the children. So they lose many years of work. They sometimes enter the labor market at an older age, and then they have lower pensions. And as we know, and as was discussed during the day, a person, an employee in Israel, when he wants a maximum pension, the bigger pension it is, he has to work many years. So this is a problem. A third, I want to talk about the employees' organizations. They must do a better job in protecting the rights of the senior employees, especially the rights of senior employees to rights towards flexicurity. And Dr. Luria talked about social partners. And we see here that the social partner, and we talk about mainly the Histadrut HaKlalit, which is the main employees' organization. And from my side, I can say that the last agreement that was made last year between the Histadrut as the labor organization, employees organization, and between the government regarding the civil service employees, the Histadrut mainly focused on money, which is, of course, legitimate and understandable, but they didn't talk about all the things we're talking about now as such, flexible working hours, flexible retirement, and so on. Fourth, the wide range of NGOs in Israel, which have a big role, must also focus their attention on senior employees' rights. Of course, they are a social partner, a very important social partner. And last but not least, and this is something Dr. Luria and I focus a lot, is the courts. The courts must rediscover and creatively invent senior employees' legal rights. And we must now go back, and I'm finishing, to Tal Golan. Why was Tal Golan fired? Why did the court, the labor court, approve Tal Golan being fired? Tal Golan, we talk about the IBM.
I did not give the end of the story.
Okay, so I'm going to tell you the end of the story. He was fired. Not the court. Said he identifies with Tal Golan, and he says he is fired. It's okay in the injunction case, not in the main case, which is not finished yet, as Dr. Luria said. He was fired because he lied to his employer, and not because of his age, and because of misconduct of behavior. As we know, Piore talked many years ago, and it's still very efficient, this hypothesis, is that when an employee makes a decision in the labor market, sometimes a decision that is looked upon as rational, as one when he had choices, actually in a labor regime, in an economic regime, where there is a lot of no choices at all, and actually with a wide range of discrimination, age discrimination, actually Tal Golan maybe had no other choice. So I talked about 5 different types of action combined together. Maybe this can lead to senior employees to a better protection of their rights. Thank you.
Thank you.
Okay.
Thank you for your interesting presentation and comments. One thing that I think that we should consider is the individual preferences. There is a strong assumption that people want to continue working in the whole discussion here. According to Israeli surveys, only 5% of those 65 and over, 65, not even 67, that are not in when they were in the labor force, only 5% respond that they want to continue working. Even if a job, if they with a suitable job. Most of them don't want, and the main reason for those who are continuing working, I'm not talking about the professor in the university and judges, talking about regular people working for 35 years in a factory or in what most people do in the services, and after 35 years they're a little bit tired. And they do, and so we have like a conflict between the societal needs, because we all understand that it is very difficult for society with this increasing life expectancy to sustain that. Because if we had very good pension systems, maybe we won't be discussing, because most people, unless, I don't say that the flexibility or introducing, even if it's only for one individual, that's okay. But in general, I do want to put the issue that it doesn't really relate to it's not the major problem of the Israeli senior citizens in Israel. The major problem is income, but not really the wish to go back to work. It is a societal need, but not the individual's need.
If I may answer, I think what you raise here is a very good question. I think if people in the age of 65 would know that they have more options, if somebody in the age of 65 knows that the mandatory age toward pension is 67, he or she has to go home, if he or she will know that they have more options, maybe he will want to work more, and by this view, I can reconnect to what I said about flexibility and what Dr. Luria talks about. Some people may want to retire at the age of 60, and of course we talked about stressful jobs. People work at physical jobs. I totally agree, and some people may want to work over 70.
No, I understand that, but. Yeah. I just want to mention that this early retirement and mandatory retirement age, I don't know if you call it mandatory, but the mandatory age in Israel exists not for many years, and the situation was not different before. Okay, but it was in the Chok HaEsderim of 2003. 2004. Before that, you could continue working, and people in the private sector, if they were fired, they could be, you could sue, because there was not. It's only recent. So we do have experience with this kind of flexibility, and we didn't see that many senior citizens working. So it's still, maybe we have to reframe the whole thing. As you were saying this morning, it's also a personal and individual thing of reframing and seeing our old age. But
yeah, about reframing, I may recall that there are lots of international agreements signed, I'm sure also by Israel, that mandatory retirement at any age must be abolished, because it basically constrains your freedom of pursuing a paid work beyond a certain age. And that's a classical case of ageism. So I think in principle, it should have been abolished long since. The latest documents were this International Plan of Action on Aging and the Regional Implementation Strategy and so on. And Israel is part of this community. So I think, unfortunately, most countries have not yet done so. Canada, the US, Netherlands, some countries have done so, but most countries still have not done so. But in principle, this is secondly, lying. You're entitled to lie to your future employer on certain things. You can't, for instance, lie that you're not pregnant. You do not have to say that you are pregnant. You do not have to say you are seropositive HIV/AIDS infected. You are not. So there are many things you are entitled to lie, and the employer must count on that you lie on that. You're not, for instance, meant to lie on your professional qualifications, on your previous income, if this the basis. So I think there's also some legislation on what you can lie and what you cannot lie on. And so I think in this case, to be dismissed because he was obviously forced to lie on, because otherwise he had no chance to be reemployed. I'm really puzzled that the courts would have approved of this dismissal, because it's a classical case of ageism, you know. But because would he have been 56? Obviously, okay. The third thing about this, the figure, I found this fascinating. What you said about these different forms of flexibility. I have another typology which would also include the flexibility of work organization, working time, which are lacked in your typology. Because, you know, the employment flexibility basically means hiring and firing, which is not desirable from an employee's point of view. Wage flexibility basically means wage dumping, and this is also not very desirable from a worker's point of view. But there is this, you know, shift systems, innovative forms of flexible shifts, multiple job holder schemes. There are so many Scandinavian and other country innovations which could be where you can combine flex security in a much more. So I think that would be something to. What you showed is that basically Histadrut is as conservative a union as all the union nowadays across Europe. So everything which is future oriented passes unnoticed, and the old-fashioned kind of income and is basically what they do. There's a last thing which I find interesting, that the 60 to 64 group has a much significantly higher employment rate than the young ones, which shows that, I don't know, do the Israelis young people enter the labor market so late, or is the hotel mama so attractive, or what? Yeah. Yeah. And then you travel. Yeah. Then you travel. And then you...
Can we go back to the forced retirement issue, what you call flex security? And you make the point out that it seems the correct thing to do to have these to have these tests to see that the employee is still able to do his job. I've been working here for many a year. Nobody put me through such a test. I don't see why that should be different at any age. One, I could see these tests happening to certain jobs, airline pilot, bus driver, and so on.
Doctors.
But not, I don't even know about doctors. Maybe surgeons. Maybe surgeons. Maybe surgeons. I'd be very careful how far I would go, just like I wouldn't put the judges on this test. And I know one country that does not allow this at all, this ageism, age discrimination at all. There's no such thing as forced retirement in the United States on any job. UK does have, but and in England it was off the books. So how do we keep justifying it, and how do you keep justifying you as lawyers and judges, and just because it's on the books in our book of law in Israel, it's on the book, it's a law. You know, forced retirement, and universities changed, and the collective agreement changed it to 68. So they granted us another year, and the coming agreement, which is yet to be ratified by the Ministry of Finance, puts it to 70. But that has not been ratified yet for the people on the new budget, the new pension scheme, the accumulated budget. So I don't see how that would work. And just for the lies. Some of my research is about misbehavior in organization, and we came across this book, and it's a scholarly book, From Hire to Liar, The Role of Deception in the Workplace, by Dave Schulman. And the thesis is that there isn't an employee alive or dead that has not lied at work.
And in some countries, I must point out, as was mentioned, you shouldn't ask in a job interview. You're not allowed to ask about the age, or even. By the way, in America, if I'm not wrong, the sex is not written in the CV at all. So.
Not where my parents were born.
Yeah.
And all the stuff that we have here.
Yeah, and Israel is much smaller and not yet oriented by these laws, but there are injunctions, there are several courts rulings that point out that you mustn't ask about age or the army, what you did in the army, or about your mental health, but it's still primary, not yet established a wide range. And employers in Israel ask, when are you getting pregnant? It's a very common question in Israeli. How many kids do you have? And I'm not talking about the secondary labor market. I'm talking about the primary labor market on banks, on lawyers, on accountants. I'm talking about well-educated employers.
All the way at the other end. Sorry.
Take a break and we should have around it.
At my age, who knows where they'll go.
I get the impression that everybody here thinks that the collective labor agreement is the best of all worlds. And I'm not sure about that, because we know in Israel about a few examples of collective labor agreements that make all of us pay a lot of money for our electricity, for our telephones until recently, and for many other services that we get. So they're definitely doing good for their members, but not for the economy as a whole. And you mentioned, Discussant, you mentioned twice the terminology of secondary labor market. As if I understood correctly, you mean by that a labor market in which workers are paid by their productivity, and they can be fired if they lie to their employer and things like that. So I don't see that as a secondary, and I think we should be very careful about defining what's good about collective labor agreements and what's not so good about them.
Sorry?
The El Al
Agreement?
I was puzzling because you find everywhere also.
In yes, I didn't talk about it because of time limits, but I checked also two examples of companies and the collective agreements in the companies. Yes, it's a very difficult system because you need to read all of the agreements when you look at a specific company. That's why it's more complicated. That's why I took only two. I took them only just as case studies to see that I'm not finding something different. So also in Teven, I also found the job security and income security, but I did find training arrangements, and in El Al I also found, in El Al Airlines I also found more possibilities for senior workers to work in, to change their tasks, or to move from the air, from working on air to working on ground. So I did find their interesting findings. Shall I say just a few? Okay. Okay. So a few comments. First of all, Tal, thank you very much. It was very interesting and great. Thank you very much. Jenny, I agree that of course not all people want to work, and most of them do not want to work, and yes, and probably if we can, if income security and if we have pension arrangement or social security arrangements, that is enough and sustainable. So this is, of course, this could be great. The problem is, what do we do if we do not, if the pension is not enough and the social security benefits are that low. About Shraga Koren and his lie, I didn't mention, but Tal said the case is still going on. I mean, Shraga Koren wanted to go back to work, and the court says, no, you can't right now. Maybe you could, like, if you weigh, like, in Israel, the court takes, the cases take a lot of time. So maybe, like, after 5 or 10 years, the court will say, yes, we should have, you had then a right to go back to work, but now it is too late because 10 years have passed. But what I would want to say that there is in Israel a new equal opportunity agent, which is something similar to what you have in the U.S. It's something new in Israel. It's only a few years, but it has also a lot of research about age discrimination. Does a lot of research, and it also it can interfere in court procedures, and the agencies, it's a governmental agency, they how would I say that? They went to court and say, we think you should go. We think Shraga Koren is right. They wrote like this thing to court. What else? Collective agreements. Where is Eyal? He left. I do believe in collective agreements. Now that I have no one to argue with, I can say that I believe in collective agreements. But maybe it's because I teach and I'm from labor law, so I believe in unions generally. About mandatory retirement age, it's a very big question which I won't really open here. But what I did want to say, first of all, it was very important to me to say that in Israel the mandatory retirement age is equal to man and woman by law. The women only have privileged and may have eligibility to receive benefits from the Social Security in an earlier age, but the mandatory retirement age is the same by law. About the question if it's good or it's not good, it's a very big question, and in Israel it is controversial, and today there are a few procedures in courts, and we might see, I think in the next, years, we might see new decisions with regard to that.
Just to support what